Yeah, I was just gonna say I apologize for last time. I guess our videos were posted on YouTube and I just kind of feel exposed right now. I don't think it was y'all guys, but
Buckle up, because you're about to witness one of the most frustrating cases of personal accountability avoidance we've ever covered. Miss Wienhofer is back in Judge Fleischer's court for the second time, trying to get a non-disclosure order on a 6-year-old DWI conviction. And she's about to complain that someone posted her public court hearing on YouTube, and she feels exposed. Let that sink in for a moment. She voluntarily appeared in a court that live streams all its proceedings to promote transparency. But now she's upset that people actually watched it? This case is going to test your patience as you watch someone blame their lawyer, blame the system, claim ignorance of basic legal procedures, and demand special treatment while refusing to take responsibility for decisions SHE made 6 years ago. Judge Fleischer is about to deliver a masterclass in legal education, explaining the critical difference between taking conviction versus deferred adjudication, why non-disclosure orders exist, and why she simply doesn't qualify no matter how much she complains. The prosecutor is going to cite specific government code that definitively proves she's ineligible, but will she accept it? Absolutely not. You're going to hear excuse after excuse, deflection after deflection, and one of the most entitled attitudes we've seen in this courtroom. Stick around because this is going to be a wild ride.
oh, there we go.
Ms. Wickenhofer,
Yes.
good morning.
Good morning, here. Yeah, I'm so sorry. I've been trying to get in this whole time and it was giving me problems. I apologize.
So you have filed a petition for non-disclosure on a
Yes.
DWI.
Yes.
The problem is that, and the way that I read the law, is that non-disclosures are used when someone has done a deferred adjudication, they've successfully completed it, and then they are allowed to, because they've completed successfully, have whatever case they did the deferred on sealed so that the general public cannot see it. You took a conviction on this case. If I remember correctly, you took a straight conviction on this case. So I don't think that you're eligible for a non-disclosure unless you can show me differently.
I mean, it happened like 6 years ago. So, I mean, I thought by the state of Texas, you're allowed to get a non-disclosure, non-expunge if you only have one offense of a DWI.
No, the law. No, what matters is what happened on your case. The time, the length of how long it was ago, the numerical, the number of how many you have doesn't make a difference as far as whether to grant this non-disclosure or not.
Stop right here, because Judge Fleischer just explained one of the most fundamental concepts in criminal law that Miss Wienhofer completely fails to understand. And this distinction is absolutely critical. A non-disclosure order is a legal remedy that seals your criminal record from public view, making it invisible to most employers, landlords, and the general public conducting background checks. But here's the key. Non-disclosure orders are generally only available to people who completed deferred adjudication successfully. What's deferred adjudication? It's when you plead guilty or no contest, but the judge doesn't enter a final conviction. Instead, you're placed on probation, and if you successfully complete all the terms, pay your fines, do your community service, stay out of trouble, the case gets dismissed and you never have a conviction on your record. Then you can petition for non-disclosure to seal the entire matter. But Miss Wienhofer did not take deferred adjudication 6 years ago. She pled guilty and accepted a conviction, specifically 4 days in jail with credit for 2 days served, meaning she walked out immediately with time served. She also got a 90-day license suspension and had her court costs waived, saving her about $3,500. That guilty plea resulted in a final conviction on her record, and convictions generally cannot be sealed through non-disclosure. The judge is trying to explain that it doesn't matter how long ago it was, or that it's her only DWI. What matters is the type of plea she took. This is basic criminal law that any defense attorney would have explained to her in detail before she pled guilty. But watch how she's about to blame everyone except herself for this decision.
So unless you can show me differently, I just don't think that you're eligible for a non-disclosure. I mean,
I
look,
don't,
Miss Wickenhofer, I love to grant non-disclosures because I love to see people trying to better their lives. So if I could, I would, but I can't. I absolutely love it when people try to better themselves. It's great. But you took a straight conviction. I think if I remember correctly, it was like, let me see, I can pull it up here.
my thing, it was my lawyer's decision. And to me, like, it's my life. So at the end of the day, my lawyer decided on what to do, and I didn't really know what was
That's
going
no,
on.
you can't say that because they go over all the plea paperwork with you. You know, they tell you exactly what's happening. And
Well,
here,
why would I file for guilty or anything if I don't want it on my record? That's my thing, is I wouldn't file for guilty if I
well,
want
I
it off
mean, I
my
can't
record.
really get into your mind about what happened about 5 years ago. You know, I don't know what was going on in your life 5 years ago. All I know is that you pled guilty to this offense. You were sentenced to 4 days in jail with credit for the 2 days that had, and we didn't
I
give
didn't
you
even
any
do
fines
days
and
in
fees
jail
or court
though.
costs.
I didn't do any days in jail.
Sorry?
I didn't any what you're saying right now is not what happened. So I didn't
You
do four
got
days
what's
in
in
jail.
essence called time served, meaning that you walked out of here because you pled guilty and you got a 90-day license suspension. The sentence technically is 4 days in jail. We gave you credit for the 2 days that you did, so you didn't have to do any jail time.
Oh,
The
okay.
only thing you did was incurred a 90-day license suspension. I even rolled your court costs so you wouldn't owe anything, where normally people pay around $3,500. So we also did that for you. So, but by virtue of the plea, you're not eligible for disclosure.
And there it is, the classic deflection that drives judges absolutely crazy. It was my lawyer's decision, and to me, like it's my life. So at the end of the day, my lawyer decided on what to do, and I didn't really know. Absolutely not. Your lawyer cannot force you to plead guilty. Every single defendant in America has a constitutional right to reject plea deals and go to trial. Lawyers advise, they recommend, they explain the pros and cons. But the final decision is always yours. And Judge Fleischer immediately calls her out on this nonsense. You can't say that because they go over all the plea paperwork with you. They tell you exactly what's happening. Here's what actually happened 6 years ago. Her defense attorney explained her options, walked her through detailed plea paperwork that spelled out every consequence of pleading guilty, answered all her questions, and then she voluntarily signed multiple documents acknowledging she understood everything and was making this decision of her own free will. Then she stood before this very judge, raised her right hand, and verbally confirmed under oath that she understood she was giving up her right to trial, giving up her right to appeal, and accepting a final conviction. But now, 6 years later, when she doesn't like the consequences of that decision, suddenly it's everyone else's fault. Notice how Judge Fleischer also points out the incredibly favorable deal she received. Time served, no actual jail time. 90-day license suspension, relatively short, and court costs waived, saving her $3,500. Most DWI defendants would kill for that deal. But instead of being grateful for the leniency she received, she's complaining that it didn't come with future record-sealing options. This is a definition of wanting your cake and eating it too.
But I just, to me, that doesn't make any sense. So just because I pled non-consent, or I needed to plead non-consent, to me, like, I'm not, I don't go out and get into trouble all the time. I'm no criminal. So to me, like, I didn't know those things, and I don't believe that those things were communicated to me, that I had to plea a certain way. So that way, later down the road, when I'm trying to get it off my record, and it's not even about bettering my life is better than it ever has been before. It's not about me trying to, it is better. And the fact that I didn't know that, I don't feel like I should be tormented or felt, disciplined because I didn't know exactly how to plead, because I haven't ever been through this before, if that makes sense. I've never been through this before. So to me, I shouldn't be disciplined or held against my will because I didn't know exactly how to plead. I've never done this before, and I don't have guidance on how to plead because I don't know a bunch of criminals just hanging out telling me how to work the courts. So to me, it's kind of messed up because I don't know exactly what to say or when to say it. I just listened to my lawyers at the end of the day, and I still obviously didn't do the right thing. So if you could please understand that circumstance, because obviously I wouldn't have purposely meant to do this to myself by accidentally pleading the wrong thing. Obviously, I meant to plead the right thing so it can come off my record. I'm a teacher at a junior high right now. I'm actually at work now. I have two little kids. I'm trying to teach my business, but obviously, I just want it to be non-disclosure so I don't have to ever file for this anymore, and I don't have to. It doesn't have to stay with me for the rest of my life. Like, God
Well, you
forgives,
need to
I
understand,
forgive,
though.
other people can forgive.
No,
So it's
Listen to this entire rambling explanation because it perfectly encapsulates a mentality that is deeply problematic when it comes to personal accountability. Ms. Wienhofer just delivered a masterclass in excuse making. I didn't know. I've never been through this before. I don't know a bunch of criminals telling me how to work the courts. I shouldn't be disciplined or held against my will. And the kicker, God forgives, so other people should forgive. Let's unpack this piece by piece. First, ignorance of legal procedures is not an excuse, especially when you have a lawyer literally explaining everything to you. That's why defendants are required to have legal representation, to ensure they understand exactly what they're doing. Second, the phrase held against my will is absolutely absurd in this context. Nobody is holding her against her will. She voluntarily pled guilty 6 years ago and now wants to undo the consequences of that decision. Third, the comment about not knowing a bunch of criminals telling me how to work the courts is incredibly revealing. She's simultaneously trying to distance herself from criminals while also complaining that she didn't have insider knowledge on how to game the system for the best possible outcome. You can't have it both ways. And finally, invoking God's forgiveness as a reason why the legal system should erase her record is a complete misunderstanding of both theology and law. God's forgiveness and legal consequences are two entirely separate things. The legal system doesn't exist to grant spiritual absolution. It exists to maintain order, deter dangerous behavior, like drunk driving, and hold people accountable. She also mentioned she's a teacher at a junior high school with 2 kids, and while that's commendable, it doesn't entitle her to special treatment or record expungement. Thousands of teachers, parents, and otherwise good citizens have DWI convictions on their records because they made bad choices. The consequences don't disappear just because you've improved your life.
I know that you're upset with the news, but a couple things. Number one, no one forces anyone to plead guilty around here. Everything done around here is with everyone's consent, and you signed plea paperwork to that effect, indicating that you were advised, you agree with it, and you came up here and you voluntarily pled to the case. I understand you now
but why
have
would I? But why would I
triggers.
do that though? Like,
Well, how am I supposed to know why you did that?
okay, well, I
That's
made a
on you.
mistake, Judge. I made a mistake. I don't know about these things, is what I'm telling you. I don't get in trouble. I don't know what to do. I'm doing what the people tell me to do. And if I would have known that pleading guilty would lead me here, I wouldn't have done it. I did not know. I was unaware
I
and
advise you to the
uninformed.
fact, like everybody, that there's no buyer's remorse. This isn't like Target. When you plead guilty, you can return it because you don't like it. This is a lifetime decision, and every person that comes up here, we ensure that they understand that they are making a lifetime decision. Once you plead guilty, that's it. If you have any issues, you can always go back and talk to the person who represented you. But I'm telling you now that it
That was 6 years
it is
ago.
what it is.
I don't even remember who represented me.
You
Like,
should be able to look it up, and you should be able to find. Okay. I will
don't
say
even
this,
know
so
who it is.
I will say this, that the type of remedy you are seeking, a non-disclosure, even with this type of order that is granted, it seals it from the general public. All agencies will still be able to see this regardless. So if you ever apply to the state to become something, they will be able to see this, right? All this does is it masks it from the general public. So like if you apply for, yeah, well, I'm getting more than what I should, right? But if you have any issues, what you can do is talk to a lawyer. They can
So
advise
it
you
stays on my
properly.
record forever, no matter what, even if I get it
I'm-
disclosed.
Ms. Wickenhofer, I can't give you legal advice, okay? But what I'm willing to do is this, is that if you want, I can give you your money back. And if you want to, I can put this off for a couple days for you to talk to a lawyer if you'd like to see, you know,
Give me my money back for what?
for the filing fee. You had to pay a $250 filing fee, did you not?
Yeah, I guess that was in the easy expunction thing.
Sure. Oh, well, no, you had it waived, I think. Hold on a second. Let me see. You had it waived. She did a waiver, right? So that she didn't pay?
Okay.
Okay, so there's nothing to give back then. Okay. All right. So basically, long and short of it is I can't grant this for you. If you want, I can put it off for a couple days so you can go talk to a lawyer about it. And we can set you off for mid next week if you want. But I'm basically telling you how it's going to go.
I'm just confused though. How come y'all can't expunge DWIs if you only have one? I
can't-
literally
Ms.
researched
Wickenhofer, I
that.
can't give you legal advice. You need to talk to a lawyer about that.
Oh, okay.
May the state make an argument that
Please.
may assist the defendant?
This is the district attorney on your case.
Okay.
Okay.
So in the Government Code, Chapter 411, Subchapter E1, specifically 411.0735, which is the procedure for convictions on certain misdemeanors, the court only has discretion to issue a non-disclosure if they're convicted of cases other than DWIs, among other things. So DWI convictions on a misdemeanor plea are one of those cutouts in the Government Code in which the judge, even if he wanted to, could not grant a non-disclosure. So because the defendant in this case took a plea of 4 days county jail, which is effectively a time served, the state's opinion is the Government Code does not allow the court to issue or grant a non-disclosure in this case.
This is the moment that should end all debate, but spoiler alert, it won't satisfy Miss Wienhofer. The prosecutor just cited the specific statute that definitively answers her question. Government Code Chapter 411, Subchapter E1 explicitly lays out the requirements for non-disclosure orders, and her case doesn't meet the criteria. The prosecutor explains in clear terms. Because you took a plea of 4 days county jail, effectively time served, the Government Code does not allow the court to grant non-disclosure. This isn't the judge being mean or arbitrary. This is black-letter law. Judge Fleischer also delivered a critically important piece of information earlier that she seemed to miss. Even if she were eligible for non-disclosure, it only seals records from the general public, government agencies, law enforcement, professional licensing boards, and anyone conducting background checks for positions of trust like teaching can still see the conviction. So even in the best-case scenario where she's somehow qualified for non-disclosure, it wouldn't accomplish what she thinks it would. Her school district would still be able to see it. The Texas Education Agency would still have access. Any professional license application would still reveal it. Non-disclosure is not the same as expungement, complete erasure, and she seems to fundamentally misunderstand the difference. But here's what really stands out. Judge Fleischer is being extraordinarily patient and helpful. He offered to continue the case so she could consult with a lawyer. He tried to refund her filing fee. Turns out she had it waived, so she paid nothing anyway. Another break she got. He's explained the law multiple times in different ways, and she still doesn't want to accept the answer.
Because I pleaded guilty. But either way, what the judge is saying is that even if it's a non-disclosure, it's still probably applicable to see through other employees. Like they're able to see it anyways. So I guess it really doesn't matter. Is that what you're saying, Judge?
Ms. Wickenhofer, I can't give you legal advice. I can't. As much as I'd like to, I can get in trouble for doing that. So Mr. Haddad was nice enough to tell you why you're not eligible for it. The only thing I can tell you now is that if you want, you can go talk to a lawyer, and I'm willing to give you a short reset for you to go do that to see if there's something else. but you tell me, what would you like?
That's fine. I guess a reset, and then I'll call them and ask them.
Okay. Tell me what day next week do you want to do this again?
Wait, can we do it at the same time? Like 10:30 through 12? That's 10 to 12. I'm usually off. So
Sure, of course. Tell me what day.
any day, I guess Monday.
Is that enough time for you to go talk to a lawyer?
Yeah, I'm gonna call them right now.
Okay.
Yeah,
Remember,
I have
lawyers,
them.
remember, lawyers are really busy, so be patient. Don't expect them to just jump at, just, you know.
It's not a lawyer. It's a expansion people. They're the ones who's working it, not
Hey,
me.
remember,
Not a lawyer.
talk to a lawyer. Don't talk to these people who are not lawyers, because they may give you shoddy advice. So be careful who you
Okay.
talk to, you know?
Okay. Yes,
If you
sir.
talk to some Joe Schmo who tells you they know. All right.
What day?
So what, do you want Monday?
Yeah, Monday sounds good. At what
Okay.
time?
All right, done. Same time, noon on Monday.
Okay, sounds good. Thank you.
Yes, ma'am.
Okay, so that was the end of hearing number 1. Now comes hearing number 2, which happened a couple of days later, and you'll probably figure out why this ruffled our feathers a little bit and perhaps got us to go ahead and make a video on this matter. Enjoy.
I have Miss Wickenhofer here. Remember the non-disclosure from Friday?
Yes.
Yeah, I'm here.
Miss Wickenhofer, good morning, or I guess good afternoon. So is there anything else that you have found as far as us being able to grant it?
Yeah, I was just gonna say I apologize for last time. I guess our videos were posted on YouTube, and I just kind of feel exposed right now. I don't think it was y'all guys, but I got kind of upset about it, and all kinds of people were
Look, there's no need, really. I get, and we all get emotional, we all get upset. It's not a big deal. And I have lawyers here that they get upset. We all get emotional because there's a lot at risk. There's a lot at risk.
Yeah, well, I'm just upset that someone was recording me during this and posted it on YouTube, and there's like, I don't like my business being out there like that. I'm a very private person, and now I just feel kind of,
I mean,
privacy is
I
kind
live
of.
stream the proceedings so that everybody gets a view of how court works, everywhere. So
I understand. It's just, I didn't know that. I knew that it was live stream. I just didn't know other people could come in and record it because they have nothing better to do. So that's irritating. But anyways,
what would you like? Go ahead.
No, go ahead.
And here's why this case went from "we'll pass on this one" to "we absolutely need to make a video." Miss Wienhofer just complained that she feels exposed because her court hearing was posted on YouTube, and she's a very private person who doesn't like her business being out there. She even throws in a passive-aggressive jab. Other people could come in and record it because they have nothing better to do. Let's be absolutely clear about something. Court proceedings in the United States are public record. The Sixth Amendment guarantees a right to a public trial specifically to prevent government tyranny and secret judicial proceedings. Judge Fleischer's court live streams hearings to promote transparency and allows citizens to see how justice is administered. When you appear in court, whether as a defendant, plaintiff, witness, or attorney, you are participating in a public forum. If you wanted privacy, you shouldn't have driven drunk and gotten arrested for DWI. This is the consequence of your actions becoming part of the public judicial system. But here's what really makes this complaint so tone-deaf. She's currently in court trying to seal her record from public view through a non-disclosure order because she doesn't want people to know about her DWI conviction. So she understands that criminal records are searchable by the public. She's concerned about her reputation and employment, and she wants the court's help to hide her past. Yet she's upset that the court proceeding itself is public? The cognitive dissonance is stunning, and the dismissive comment about people having nothing better to do is particularly grating. People watch court proceedings for many legitimate reasons: to learn how the justice system works, to hold judges and prosecutors accountable, to educate themselves about their legal rights, or simply because they find legal proceedings interesting. There's nothing wrong with any of that.
I have looked at the statute. I don't think that I can grant your non-disclosure.
That's fine.
Had you done a deferred on the DWI, which is typically what non-disclosures are reserved for, we could grant the non-disclosure, but when you take a time served and it ends up as a conviction, that stays there and it's like that for life.
I understand. I thought I did do deferred. I know that my license got taken away for a while for, but I was actually texting my lawyer and I thought I did do deferred.
No,
Um,
no, and I wish, look, ma'am, Ms. Wickenhoffer, I wish I could. Because I really like it and I love it when people try to better themselves, but I can't.
I understand. I just
Yeah.
need something in writing that tells me why I'm not eligible and something specific. If you could send that to me.
I'm not going to do that. I mean, what I can do is I can just give you the order that says denied, but I mean, I'm not going to give you a reasoning. I'm telling you, you're just not eligible for it. So
I understand, but the people that I'm working with are telling me that I am. So is there any way that your secretary or someone could just jot down reasons as to why I'm not eligible? That way we can get something going on because I've already told you this, but I've already hired people to work on this case. So I need the reason why, or if you could just tell me why and I'll write it down and I'll send it to them.
Judge, well, I mean, we live streamed, the state gave its position. They could use that.
I mean, I'm not going to.
I just need to know why I'm not eligible. Why? Give me the exact reason so I can write it down.
You pled guilty to the case and you took a conviction. As a result, you're not eligible for the non-disclosure.
So that's it. That's the only reason.
That's it. Yeah, that's it. So, do you have the order for Miss Wicken? Steph, do you have the order for Miss Wickenhoffer? We can put it in the queue. I'm going to put the order in the queue, or they're going to put the order in the queue and I'm going to sign it. Okay. You should be able to get a copy of it off of the district clerk's website within like 2 to 3 days. That way you can also have a copy of it. Okay.
Oh, okay. Yeah. Cause that would help me out. That's why I feel so lost. Cause it's been a while. So I don't even
I
know
wish I
really
had better
what
news
happened
for you,
6
man.
years ago. That's a long time ago. So.
Yeah. Okay. Okay, ma'am.
How can I get it? I just go to the website?
Yeah, just go to hcdistrictclerk.com, put in your cause number, and you should be able to go to the images tab, and then you can print out a copy of it.
Okay. I'm pretty sure they have it. So you said the only reason is because I pled guilty and I took a conviction.
Correct.
And I didn't take deferred. I'm gonna ask my lawyer because I don't have it in writing, but she should know. And then
You can also, when you go to the district clerk's website, you can also pull a copy of the judgment as well. All that's there it's public record. So you can pull all those documents there from the district clerk's website and you can see what you did. So it's right
Okay.
there in black and white. So it's everything's there for you.
Okay.
So that you can see it. A copy of the information, the charging document, the plea paperwork. It's all on there for you to see.
Okay. All right. Appreciate it.
Yes, ma'am.
Thanks. Have a good day. Bye-bye.
Take care.
This case highlights a hard truth about personal accountability in the legal system. Across 2 hearings, Ms. Wienhofer appeared before Judge Fleischer asking to seal her 6-year-old DWI conviction through a non-disclosure order. The problem is simple. She pled guilty, accepted a conviction, and served jail time instead of choosing deferred adjudication, the only path that generally allows non-disclosure. At the time, she received an extremely favorable deal: minimal jail time, a short license suspension, and thousands of dollars in waived court costs. She signed paperwork, confirmed her understanding in court, and voluntarily accepted the consequences. Now, years later, she claims she didn't know and blames her former lawyer. Judge Fleischer patiently explained multiple times that the law clearly prohibits non-disclosure in her situation. Citing the relevant statute, the prosecutor confirmed the same. The second hearing added irony. She complained about feeling exposed because her public court hearing appeared on YouTube, despite court proceedings being public by design. The contradiction was striking. She wants privacy from a public conviction while objecting to public transparency. If you found this case as frustrating and educational as we did, please hit that like button. Share this video with anyone who needs to understand how non-disclosure orders actually work, and make sure you're subscribed to our channel with notifications turned on. We bring you the most compelling, thought-provoking, and sometimes infuriating courtroom moments that reveal the real-world consequences of legal decisions. Thank you for watching, and remember, court proceedings are public for a reason,